Good day, everyone, and welcome to today's program with the Phoenix Center on Tariffing the Internet. At this time, all participants are in a listen-only mode. Later, you will have the opportunity to ask questions during the question and answer session. You may register to ask a question at any time by pressing the star and 1 on your touch-tone phone. You may withdraw yourself from the queue by pressing the pound key. Please note this call may be recorded. I will be standing by if you should need any assistance. It is now my pleasure to turn the conference over to the president of the Phoenix Center, Mr. Larry Spiwak.
Thank you very much. Good morning, everybody. My name is Larry Spiwak. I'm the president of the Phoenix Center, and we'd like to welcome you to our teleforum this morning on tariffing the Internet. Before I get started, a couple of administrative matters. Hopefully everybody received the confirmation email from Eventbrite, and there should have been a web page on that email, and I'll give that again, where you can download the slide presentation for today's teleforum. It is http, our web domain, phoenix-center.org/tariffing the Internet, just as it sounds, just as it's spelled, .html. If you go there, you can then see the slides for today's presentation will be there. They're in Adobe PDF. Just click on it and you can follow along. For those people who would like to join the conversation on Twitter, we're going with our standard hashtag, which is PHXPolicy. So with that dispensed, again, I want to welcome everybody and give a little bit of an intro about what we're going to be talking about today. For those of us who have been following the net neutrality debate, we all know that there has been lots of calls for reclassification of broadband internet access from the current status, which is a Title I information service, to a Title II common carrier telecommunications service. I think it would be fair to say that the vast majority of people who are advocating for reclassification have given absolutely no thought to what that actually means. It is as if, reclassification is the magic button and then we can end all and be all. If the FCC decides to reclassify, then that triggers a series of very complicated events. And as George and I, my partner, Dr. George Ford, is our chief economist, were thinking about this a while back, we thought it would be a good idea sort of to write out what we thought what would happen if the FCC reclassifies, and to take it through its logical extension based on the case law, FCC precedent, and of course the Federal Communications, the Communications Act. So what we're going to do, what we found in our paper, and George will walk through that in a moment, is essentially two things. One, upon reclassification, edge providers become customers of a broadband service provider, and as such, you now have to tariff under Section 203 broadband internet access, probably at a positive price. But equally, if not more important, that you cannot forbear from those tariffing requirements under Section 203 of the Act because of what's called, because the FCC has described each broadband service provider as a terminating monopolist, i.e. everybody is dominant. And George will get into that in a little bit. So whether this is a good or bad result, we leave to others. But I think it's very important that we sort of work through in a serious way what reclassification actually means. So we have a fantastic program in store for you. First, we're going to have Dr. Ford present our research. And then we have a fantastic discussion panel with some of the most talented telecom lawyers I know, each having 20 years of experience in this business. So, and then after that, we're going to end up with some Q&A. So hopefully everybody has their slides. And now let me turn it over to Dr. Ford, who will present our paper. So George, take it away, please.
Great. I hope everybody has the slides to go through. If you don't, then you'll just have to listen. I'm just going to go through. These slides are probably better suited for live presentation, but we don't have that today. I've had a couple of bad experiences with the online presentation software, and I haven't gotten over that yet. So we just decided to go old school today, make sure it got done. So I'll just indicate when we're moving on, and we can pretend that it's going smoothly. I want to begin. If you do have any questions, I'm going to go through this quickly. If you do have any questions, you can go to the paper or contact us later through email or ask some questions today. All the material is well documented as always in the original paper. I'm going to begin at slide 5 to provide a brief background of the problem. The reclassification debate is essentially about labeling broadband as either an information service, and if that, then the FCC would attempt to regulate under Section 706, regulate to protect the open internet, however you wish to define that. And alternatively, it could classify broadband as a telecommunications service and then regulate under Title II. These classifications are formal classifications, and they aren't just empty words. They put you in a certain basket, and whatever basket you're in depends on how you get treated. Traditionally, information services are viewed as being more lightly regulated than telecommunications services, and the Title I authority is ancillary, generally viewed as not as direct, but it has expanded the agency's authority significantly over the years and has been used quite effectively by the Commission to regulate all sorts of businesses, including some businesses people would say they didn't have any authority to regulate at all, such as the cable industry early on. The next slide, slide 6, the 706 approach, the FCC has attempted twice, roughly attempted twice, and both times its decisions have been sent back by the reviewing courts. Following the Open Internet Order approach, which was a fairly direct 706 approach, and the guidance of the court in the Verizon opinion, the FCC's 2014 Open Internet NPRM outlines how you would go about doing this network neutrality regulation under Section 706 as an information service. So we kind of know how that approach would look. If you go to slide 7, what we don't know very well is what network neutrality regulation would look like if we reclassified broadband as a telecommunications service and took the Title II approach. Now, this is quite fundamental and important, is how do you go about regulating? What is the mechanism of regulation under Title II? If you go to the next slide 8, thus far, at least as far as I've seen it, and no one's told me I'm wrong, the reclassification advocacy has argued for reclassification as if this legal distinction was the beginning and the end of the issue. And really, classification is a first step. It merely says, okay, now you can apply some set of regulations to this, and then the question becomes, what set of regulations are you going to apply? And this is typical in communications debates. I mean, we argue mostly about ideas. I mean, the open internet is an idea. Network neutrality is an idea, and different people have different beliefs about what that idea is, but it is not a policy. A policy is, here's the set of rules, here are a bunch of court decisions that address this set of rules and potentially modify these set of rules, and then here's how firms respond to them. It's much more complex than just saying reclassify to a telecom service. And no one has really said, okay, well, what would that look like if we were to reclassify? And we've attempted to provide answers to that question. On slide 9, I indicate that our paper, I believe to be the first and only attempt to really outline how Title II regulation gets done and offer specifics on how the FCC would protect the open internet under its Title II authority. I think that's true, and no one has I haven't read anything otherwise that provides any detail about how it might go down. Slide 10, network neutrality is regulation. What the FCC is wanting to do is to regulate the internet. I mean, that's not a question. This isn't a forbearance question. This isn't a deregulation question. This is a regulation question. So if we're going to regulate something, we've got to know, A, what transaction is it that we're going to regulate? And B, what is the nature of the problem we're attempting to solve? These are two very fundamental questions. And so the first thing to do, I think, when we consider what would Title II regulation look like, is to answer these two questions. Slide 11 is a very brief slide. It says, what is the relevant transaction? You might also say, what is the relevant relationship, or what is the relevant market that we're attempting to regulate? And I think this is a very important question. Slide 12 sort of outlines this problem in a diagram, which is a crude but effective diagram of some relationships in the Internet ecosystem. At the bottom, we have a transaction A, which is consumers buying a mass market retail service from broadband service providers. The data carriers carry traffic and dump that traffic onto the broadband service provider, who then provides it to its consumers. The edge providers over there on the right in transaction C will buy this transit service, or whatever service it is they're buying from data carriers, that gets it finally to the broadband service provider. In some cases, an edge provider may directly connect in a carrier-type relationship with the broadband service provider, and in many cases not. The relationship of interest here for network neutrality is not the consumer BSP transaction A, and it's not the carrier BSP transaction B. It is the transaction D. It is a transaction directly between broadband service providers and edge providers, and this transaction really doesn't exist formally today, but it is unquestionably, if you read the FCC's comments and others, the D.C. Circuit, for example, and even some of the advocates of reclassification, you see this is the problem. The FCC says it's the second side of the market between the edge providers and the broadband service providers. The D.C. Circuit talks about the edge providers being customers of the broadband service provider, and there's some other quotes that I'll get to later. We have many of these quotes in the paper if you want to read that in Section 3. On to Slide 13. What's important to note is that network neutrality is not a carrier-to-carrier interconnection issue. At least it's not now that. This isn't really about Comcast favoring AT&T's trunks over Verizon's trunks or anything like that. It's about the BSP going in and singling out a particular edge provider or a particular type of traffic and doing something with it, trying to charge a price to that particular edge provider, not the carrier over which that traffic is on. And this is how we get into the whole deep packet inspection concern, where we're going in and picking out bits of a particular type. That would not be a concern if we were really worried just about a carrier-to-carrier relationship, because you don't need deep packet inspection to put peanut butter on a piece of fiber that belongs to a particular carrier. Some of you old folks may remember, may know what I meant by that. So we get to Slide 14 and we see what this relationship is. The network neutrality regulations have to be placed between or within the transaction between the edge provider and the broadband service provider. And this is a termination market where the buyer is the edge provider and the seller is the broadband service provider, because this is the transaction where the deep packet inspection or the paid prioritization would occur. And if you look at the common examples people cite, where particularly in the mobile industry is trying to do a deal with an edge provider, maybe to allow the edge provider to pay part of the data package or whatever the consumer. And if you look at the quotes below, and I won't go through that now, you can look at it later, and you'll see, again, some quotes that clearly delineate this as being the relevant market. So this is the market we've got to regulate. If you move to Slide 15, we also see that this, despite the fact that many of the political interest groups want us to focus on the consumer to BSP relationship, that's not where the problem lies. And this is a quote from Public Knowledge that talks about fast lane services, where it's really the ISP or BSP interacting with the edge provider. So even there, we have some recognition that this is where the problem lies, even though they don't focus on regulating that transaction to solve the problem. I guess it's some regulation by proxy. I also just don't think it's been very well thought out. Moving to 16, why Title II? Why do we want Title II? Well, Title II gives the FCC the authority to regulate under sections 201 and 202 is primarily what is pointed to as the source of regulatory authority or power to forbid paid prioritization of internet fast lanes, or what is known more commonly as charging different prices for different qualities of service. Moving to slide 17, those familiar with Title II regulations know that this belief is false. Different qualities and different prices are quite common for Title II services, and some might even say they're mandated by Title II regulation. You can think of special access as an example. It's sort of what makes special access special is the fact that it's a higher quality, guaranteed bandwidth, symmetric bandwidth service, and that's why it's a different service which brings different prices. But it's actually quite common that this occurs. So Title II would not prohibit fast lanes. And if you've read Congressman Waxman's latest letter, you'll see that he agrees that that's the case. And I think this most basic error about Title II reveals the superficial nature of the debate over reclassification. Turning to slide 18, the FCC is attempting to control pricing of service. As I mentioned earlier, network neutrality is price regulation. It's plainly price regulation.
Hey, George?
Yeah.
This is Tom Navin. We're getting some feedback on the line. I don't know what it's related to, but I just wanted to bring it to your attention.
Is it scratchy sound or?
Yeah, scratch, right.
Yeah. Well, let's see here. Let's see if I can change my routine here. I'll go to the old style microphone. Okay, the network neutrality is price regulation. I mean, it's an attempt to control paid prioritization, which suggests a price, and as the Verizon court recognized, it may be zero price regulation, at least at the time, at least in the decision that the Verizon court was reviewing, was zero price regulation. It may not necessarily turn out to be that way in the next round, but without question, it is price regulation. It's not price regulation of the end-user market. It's price regulation of the terminating market, and again, focusing the attention to the correct market. Slide 19, once the market is defined, which is the BSP-Edge relationship, and the nature of the regulation is recognized, which is price regulation, the rest of our arguments flow quite naturally, I think, to somebody familiar with how Title II regulation is done. And how does a regulator implement and enforce price regulation under Title II to satisfy 201 and 202? And the answer is tariffs. And in fact, I've got required there highlighted in the slide. Tariffing is required. It's not an option. I mean, the FCC tried to treat that as an option years ago in the case of long distance, offering to de-tariff long distance prior to the 96 Act, and the court shot them down and said, no, you can't. It is a mandate of the statute. I've run into this issue in other cases as well. When a statute says you shall do something, it doesn't mean you get to choose whether or not to do it. You have to do it, even if you do it poorly or try to wiggle it out where it doesn't have any impact. You still have to do it. So this is tariffing is a requirement of the statute. It's not an option. Moving on to slide 20. So what you end up with here, and I think I should move quickly so people have a chance to ask questions, and our panelists have an option to talk or ability to talk. The tariff service, we end up with a tariff termination service offered, and the buyer is the edge provider, the seller is the BSP. This doesn't exist today. This would be a new access charge in the industry. Common carrier services are offered for a fee. That's statutory. In rate regulation, you don't normally set a price to zero. That would be considered confiscatory. Nor can you set the price arbitrarily. And I think saying I want it to be zero just because I want it to be zero is fairly arbitrary. Services cost money to produce, and I think that it would be a pretty difficult sell to set that price at zero, but who knows what the FCC will attempt to sell. Slide 21, normally how this would work is the BSP would file a tariff and say, here's the service I'm offering and here's the prices I intend to offer it at various qualities and various prices. And then the FCC would look at that and say yay or nay. And if it says nay, then of course the BSP can challenge it, and that could lead to a rate case and probably litigation if the FCC tried to hold ground, and that'd be a fun show to watch, I think. I don't know how good it'd be for the internet, but it'd be fun to watch. So why not forbear, slide 22, and let's jump to slide 23. Why not forbear from Section 203? And this is the argument that some people have made, and even though people talk about forbearance to a Title II light, we rarely see sort of a list of forbear from this, and keep this, and this is why, and this is how it's going to work. But if you were to de-tariff, first it really does nothing. I mean, forbearing for 203 does not mean the FCC can set a rate at zero, and it doesn't mean that the FCC can mandate discriminatory prices. Section 10 forbearance requires that rates be JNR and requires that rates be non-discriminatory, which is essentially saying it has to comply with 201 and 202. So the fact that you say you don't have to file this document which describes the terms and conditions of your service doesn't mean that the FCC gets to set a price at whatever it wants to. It still has to comply with the statute. So first, it just doesn't do anything. And second, it would be very difficult because the whole network neutrality problem is a problem of a terminating monopolist. All the negative incentives or perverse incentives that the FCC attributes to the broadband service provider arises out of its gatekeeper role. So you're essentially going to say, I'm going to de-tariff a dominant carrier's prices, which just has no precedent and just doesn't make any sense. And it's not a situation like in potentially some other markets where the terminating monopolist really isn't a problem, is the source of the problem. This is the problem, the terminating monopolist. So you're saying I'm going to forbear from monopoly when the monopoly, this particular monopoly, is the main problem I'm trying to solve. So I don't think that's going to work either. And then if you read the Orloff case, which is really where this whole paper comes from, at least it stimulated my thought about this, is if you do forbear from tariffing, then the FCC essentially surrenders the ability to enforce 201 and 202. It says something else is going to enforce it. Competition is going to enforce it. And the Orloff case stands for that proposition where a customer actually files a complaint, and we eventually had a legal dispute, judicial dispute over whether or not wireless companies can offer individualized pricing. And the court said, well, when the FCC forbear from tariffing, it eventually said, these guys can discriminate. The discrimination they're doing is fine, and the FCC couldn't enforce it. Now, there was some language that it could enforce, say, racial discrimination or something like that, but not just the variety of prices that are being offered to the market. So if I sum up this thing, really what we have is we define the market, BSP to Edge. We know that this problem arises out of terminating monopoly. We know that network neutrality is price regulation. So then under Title II, network must be implemented by tariffing of termination service. I mean, this is a fairly logical flow based on the record and the statutes and how this thing has played out. I do want to stress here just briefly that when this paper is not attempted to scare anybody or make Title II a boogeyman or tariffs a boogeyman, I really don't have any judgment about this at all. I mean, it's just how it could play out. I think the most logical way, the most obvious way that Title II regulation would play out in this context. And some people may view it as a good thing, and some people may view it as a bad thing. I don't know really how people would consider it, and maybe that's why we hadn't gotten any more criticism than we've gotten, because I don't know really how people feel about it, and I suspect our panelists may have some different views on it. But really the only purpose of this was to say, here's how Title II works, and here's how it would work in the particular context of network neutrality. And with that, I'll turn it over to Larry and our excellent discussants who probably, I was counting the other day, I suspect that the three discussants, Larry and I, probably have about 140 years of telecom experience. So it's an informed group of folk. Thank you.
Thank you very much, George. I appreciate that. So let's move now to our discussion panel. We have, as George mentioned, I mentioned, a really fantastic group of very, very talented telecom lawyers with a significant amount of experience in this business. We have Jeffrey Lanning, who's Vice President of CenturyLink, Tom Koutsky, who's the Chief Policy Counsel of Connected Nation, and our good friend Tom Navin, who's not only is he a partner at Wiley Rein, but he brings an excellent perspective as the former chief of the FCC's Wireline Competition Bureau. So, gentlemen, thank you so much for joining us. To get the conversation started, let's just go over some general background and just talk about the administrative burdens of tariffing. Again, I think a lot of people just don't have any concept of what that means. So the first question I have is actually for Jeff, given the way your company is organized. Let me just ask you off the top. I mean, you guys file a lot of tariffs. How long does it take CenturyLink to prepare a tariff? What does it involve? Is it labor intensive? Do you have to hire outside consultants and lawyers? I mean, is it compliance cost? I mean, what is it that you have to do this?
Good question, and thank you for the opportunity to be on the panel. We actually have a whole department with hundreds.
Speak up, Jeff. But sorry.
No, that's okay. We have a whole department with hundreds of people in it whose job is filing tariffs, both state and federal. And yeah, it takes a long time. It takes months. Depending on the type of tariff we're filing and the level of regulation and cost justification, it can take as much as 4 or 5 months to put together an annual filing. And every time we do an update, that also takes a significant amount of time. An update's where you might replace one page in the tariff because you're changing a term or a condition or something. Tariffs are expensive. They cover every possible aspect of the relationship, including how dispute resolution would work. In many ways, they basically substitute for contract law. And sort of as a result, people enter into contractual arrangements without even sort of realizing it, and they're bound by them every time they buy a tariff service. And so it sets out everything and requires, extensive input from all kinds of resources. We actually keep all that in-house because it's become it is inherently a part of our business. The tariff rules were set up long ago to govern a monopoly, but in the competitive world, they are a real drag because they make it very hard to respond to competition, to respond to the market, to come up with new things. They basically drive everything towards a one-size-fits-all service. And smaller companies, they do have to rely on outside consultants. There's an entire industry for the smaller phone companies of consultants that help them just with tariffing. And in fact, there's an association, the National Exchange Carrier Association, or NECA, that handles the tariffing for most of the smaller companies. It's a multi-million-dollar business, indicating the administrative costs involved.
Do you have to litigate tariffs? How often does that happen?
So every tariff, in effect, is litigated on one level in the sense of you have to get approval for it, as George mentioned. So when you file it with the relevant regulatory body, you wait for them to review it. They'll come back to you and then say whether it's okay or not. We have, over time, come up with some processes that allow it to go into effect while it's being investigated. And then you get complaints under it. If it's rejected, then you go to court, and you can go to court and say, well, we think it is okay, and that the regulatory body is wrong. So, in essence, everything has a little bit of litigation with it, and then occasionally it turns into a lot of litigation.
Huh. Interesting. Well, let me turn over then to Tom Navin. I actually have 2 questions for Tom. First, if you wouldn't mind putting on your former bureau chief hat, and we can delve into some of your war stories. Based on your experience when you were at the commission, I mean, how does it work at the commission? How long does it take for a tariff to move through the pipeline? What happens once you file it? Just see if you can just give us a little background with that, Tom. Is Tom there?
I think we lost him.
Sorry about that, guys.
Yeah, mute button.
Yes, thank you. They didn't teach us that at the FCC.
Yeah, well, this is a telephone. We don't expect you to know how to operate.
Back when we were there, we didn't have mute buttons. We had 2 tin cans and a piece of string.
I understand. So I actually started in the pricing division in 1999 when Bill Kennard was chairman of the FCC and Bill Clinton was the president of the United States. The push at that time was for increased pricing flexibility. As you guys, I'm sure, remember, the Bell companies were, fighting with long-distance carriers, and ultimately they were looking for was increased flexibility with regard to tariffing and increased flexibility with regard to pricing because they were starting to feel the impact of the 96 Act, and they needed to be more nimble with regard to responding to competition in their various LATAs. So the answer to your question is that I started at the FCC during a period of time where the agency was moving towards decreased tariff filings. It had already made the determination in 1994 that it was not going to allow wireless carriers to file tariffs either for customer service or for interstate access charges. And it made the same determination with regard to long-distance carriers, and of course that makes sense. As the markets became more competitive, the Commission moved increasingly against tariff filings or restrictive tariff filings because, competition, as everyone has observed, as Jeff observed, and as both Larry and George have observed, as markets become more competitive, there's less need for that type of regulation. So when I became bureau chief under Kevin Martin, there was significantly less to do with regard to tariff filings because the market, in particular for phone service, had become increasingly competitive as the wireless providers basically cannibalized the long-distance business by offering one-rate plans and eliminating the ability of long-distance companies to charge for the service on a per-minute basis. So, Kevin Martin referred to that division as the price controls division. So he very much minimized the amount of work we did. That said, I would just observe, some of the timelines that are outlined both in the rules and in the statute. The Commission does have authority by rule, or I should say the Bureau has authority by rule, to delay the effectiveness of a tariff that is filed on less than 120 days notice. So that's a relevant time period, as is the time period identified in the statute itself, which says that if the Commission suspends a tariff, it must resolve its investigation within a 5-month period of time. So, Larry, I think that gets to some of the issue that you were raising, which is this is not a process that moves particularly quickly. And as it relates to the primary inquiry, which George identified, which is this inquiry under 201 and 202, the primary question is, are the prices being charged reasonable? So in the circumstance you've identified, and what makes this internet neutrality debate so complicated is that people tend to face towards the consumer and make one argument, and then face upstream, towards the internet backbone and make a different argument. And I think George did a good job of identifying the distinction. The reality is that, facing the consumer, the consumer oftentimes has as many as, 5 or 6 different broadband platforms available to him today. So the consumer has an increasing number of broadband options. And as it relates to the idea of, terminating monopoly, that is fairly foreign as it relates to the internet, because the Commission has, for the past 18 years, treated the internet backbone market as a competitive market. The only circumstance we can analogize to is the idea of the rural carriers or CLECs tariffing access charges for terminating traffic that is created significant distortions in the market, and there's actually significant litigation going on to this day where rate of return carriers in particular have tariffed a certain charge for terminating calls to their network on a per minute basis, and then have stimulated traffic that increases the number of minutes that they're receiving over their network, and as a result has caused carriers who are terminating traffic to them to pay significant amounts of money. So that is one of the the biggest issues going on today in telecom that involves tariff filings, and it's probably not what we are aiming for as it relates to internet service.
Right, and just a real quick putting on your private sector hat, when we were talking about you participating, we were talking about the special access data request, and you had said that even some of your clients, your smaller clients, the compliance costs were just astronomical. I mean, is there a compliance issue if we started having to tariff broadband internet service? You think about all the small edge providers would then have to go out and hire some fine attorney at Wiley, Rein. I mean, how would that work?
Yeah, there's significant compliance costs on the outside, and I will tell you with regard to the FCC's ability to manage that process, it is limited. A lot of the resources related to tariff filings, have shrunk, in proportion to the amount of competition that exists in the market. So as fewer and fewer carriers were able to make tariff filings, there are fewer and fewer people at the FCC who were able to process those filings. So the FCC is not set up for it, and similarly, the companies are not set up for it. As the markets have become significantly more competitive as it relates to wireline telephony or as it relates to internet itself, the carriers don't have people that are assigned to do tasks that were done back in the 1980s. And the ability for them to hire those resources in-house is limited. And as Jeff observed, what they will have to do is they have to go to outside law firms and consultants like Wiley Rein, and of course pay a significant hourly fee for us to be involved in that process. So yes, the answer is, in particular for smaller carriers, even for mid-sized carriers, it will be cost prohibitive.
All right, well, let me throw it over to Tom Koutsky, who's our resident E-rate expert, because he's so involved with all the great work that Connected Nation is doing. Tom, if you wouldn't mind just if you talk about it a little bit from your perspective, if we end up reclassifying and it becomes a telecommunications service, broadband internet access, that means that you are now subject to universal service and E-rate, so forth and so on. If you could sort of summarize as you see it, how this reclassification would start to affect E-rate, would we have to start with essentially would the edge providers now be paying in the universal service, compliance costs, what has to be done? What are your thoughts on that?
Well, yeah, and first of all, I appreciate the opportunity to participate on the panel. I really think I would encourage those who haven't read George's paper to look at it, just because I think it's important to think about the consequences of classification. Like George, I'm kind of agnostic on this point to a certain extent. My general perception of tariffs is that they're not necessarily bad if you think of them in the context of perhaps more efficient ways of managing a commercial relationship than requiring one-to-one negotiations. And that was the original idea behind a tariff, was, as Jeff said, was to have a set of contract clauses that were transparent, that anybody could look at, and they kind of knew what the rate was, a little bit like when you used to go into a hotel and they would post their room rate, so you knew you weren't getting, a higher room rate just because it was midnight and raining outside. So I do think that there are some uses, that there's some utility to tariffs with regard to lowering the transaction costs in the industry. And an affirmative part of that is to essentially put those costs into one location, such as a department at CenturyLink, rather than to have everybody in the industry spread out all of those costs kind of simultaneously. All that said, I'm not entirely sure that this is the right context to think about it, but I don't think that necessarily tariffs are bad. The kind of important part of reclassification is, though, as you said, Larry, is that if we do classify Internet termination services as a telecommunications services, two things happen that I think aren't being talked about all that much. The first one is that there is almost a presumption of payment for that. We have gotten to this point in the Open Internet debate, thinking about, should the broadband providers be, requesting payment from edge providers. I think in a Title II tariff environment, yeah, I mean, the presumption is that they would be toll keepers. So I do think that it's important that we haven't really followed that through. The other consequence, though, is, of course, that if it is a Title II telecommunications services, the revenues from any payment from an edge provider to a broadband provider would be presumably an internet or an interstate telecommunications services revenue that would end up being assessed in part of the contribution base for the Universal Service Fund. Now, as we know that the contribution base for the Universal Service Fund has shrunk significantly, frankly, probably Tom Navin, probably since it was created in 1997. I don't think it's ever gotten bigger. I think it's only gotten smaller. So increasing the contribution base for the fund, would have the effect of kind of lowering the general contribution rate that we currently see. So I'm a little bit, again, also agnostic as to that point, where it's not clear to me that would be necessarily a bad thing, that broadband edge providers would, make some kind of contribution toward the Universal Service Fund. But it is an important consequence that really isn't being focused on or talked about in the context of Title II. It would have the effect of shifting the flow of money in the industry rather significantly, not simply between edge providers and broadband providers, but also within the universal service system in ways that have not really been fully thought through, at least as of yet.
Oh, that's great. Okay, so moving on to sort of our next topic, and a great risk, but I will put this out to the panel. I'd like to ask you all a very straightforward question. Is the scenario that George and I outlined in our paper plausible? Jeff, Lanning, what do you think?
It's absolutely plausible. I think the counter argument some people would try to make is, well, wait a minute, in telecom, while we still have tariffs, we're moving to bill and keep, and they have that in wireless, and why couldn't that be the case here? And then I think the real point there is that's a relationship between two carriers, and what is being discussed is actually a relationship between a carrier and an end user. And so if we're going to have that relationship, then the scenario that George lays out is very plausible. We do de-tariff most end user services, but only where we don't have monopolies. I mean, the forbearance requirements are pretty clear that you have to point to competition as protecting the values that would be protected by the tariff, and if you have a terminating monopoly, then you can't de-tariff. So this is part of, to the broader theme of not having thought things through. I think this is really kind of an important point. In many ways, the scenario that George has laid out is exactly what everyone, it flows directly from the statements and the arguments that are being made in the net neutrality debate, but it produces a scenario that we really haven't seen before, because transactions are usually regulated in clear ways, and we have inter-carrier relationships, and we have a world around that. And by the way, because of tariffs, we have lots of arbitrage. I think Tom Navin mentioned that, and lots of gaming and lots of other stuff, and we would definitely see that. That's there are positives, as Tom mentioned, to tariffing. There are negatives, and one of the negatives is the gaming and arbitrage opportunities it sets up, because it creates a sort of a transaction that cannot be a contract that can't be avoided. So I think it's a very plausible scenario. I'm not sure it's the only scenario, but other possible scenarios are we turn edge providers into carriers themselves, and then they become Title II carriers, and then that's got its own set of interesting consequences. That might be, so if we wanted to avoid all these tariff problems and move to an inter-carrier compensation type of world, bill and keep and all of that, then we might have to turn the edge providers into carriers themselves, and I don't think anyone's thought that through. But Google is a Title II carrier. It's certainly not what they have in mind, when they're arguing for net neutrality.
And this, I think what we would likely to see, if this were to follow through as George outlines, which I do believe is plausible, is you might see a category of providers who prop up simply to be the Title II carrier that terminates edge providers' traffic. I think a logical response of the industry would be almost that arbitrage phenomenon that Tom Navin discussed earlier, where companies would become artifices purely, and the network could get engineered purely for the standpoint of either being able to take advantage of a tariff provision or to avoid a tariff provision. And I think that, in the end, is not really what the chairman is trying to drive at with regard to open internet rules. I don't think that's the kind of industry he wants to see. I think what that's
but is
not
that the
necessarily
unintended
transparent.
consequences, though?
Yeah, that's not necessarily transparent. That's not necessarily resulting in this kind of no toll lanes approach. I think it's actually almost flatly inconsistent with what the stated goals that the chairman has are.
Which is interesting because we already see that to a degree today in the unregulated space, right? So we've had this notion that there won't be fast lanes, and that broadband service providers will basically just be open pipes. And in order to avoid the inevitable sort of congestion and other things, and to prioritize traffic, we see content distribution networks develop, like an Akamai or a Cogent, which basically do all the things that we don't want the broadband service provider doing, and they do it for quite a fee, actually. So it's interesting. Of course, it's also interesting because under the Waxman proposal, they would still be able to do what they're doing just fine. So we would still have fast lanes, but my gosh, they wouldn't be fast lanes by big carriers, I guess, is the big benefit.
Tom Navin, you got something?
I just want to be on record when Jeff said, Tom said tariff filings aren't bad. He meant Tom Koutsky.
There you go. Well, let me ask you this, Tom, and this is something we talked about. What about the federalism impact? I mean, if you reclassify and become the Telecommunications Service, do states get involved? Do we now have an intra-state portion of broadband internet access?
Well, you sure could. I mean, there's so much working at cross purposes here, not the least of which is the findings that you would have to make to impose regulation in the first instance, impose Title II regulation in the first instance, will be directly at cross purposes with the findings that you have to make under the forbearance provisions for purposes of eliminating the regulations that you don't want to apply. So as a practical, legal exercise, that order would be virtually impossible to write. So in addition, although the forbearance authority makes it clear that once the FCC forbears from a particular regulation, the states may no longer enforce that regulation, it doesn't mean that the states are taken completely out of regulation of the intrastate telecom service. So the answer to your question is yes. By calling it a Title II service, you empower 50 states and the District of Columbia, as well as the territories, to regulate internet services, and they certainly would have a voice in this circumstance.
Well, let's talk about the forbearances. We're running short on time, but I do want to touch on this point. Is anybody on the panel aware, I couldn't find the case, George couldn't find the case, where the Commission has de-tariffed in the face of dominance, i.e. terminating monopoly? I'm not aware of any, and I think that's a major problem that the FCC has in its forbearance analysis. I mean, we're not talking about getting rid of Armis. We're talking about de-tariffing under 203, or even forbearance of unbundling obligations where they have dominance, where there's competition, like in the Phoenix Omaha case, which Jeff is intimately familiar with, they granted, but in the Phoenix in the Quest Phoenix forbearance case where there was no competition, they didn't grant forbearance. Any thoughts on that to the panel?
I would just emphasize that, as it relates to the forbearance determinations the Commission has made, is I think almost uniformly they've taken the full year plus 90 days to resolve each and every one. That's how easy it is to apply the forbearance criteria to a regulation for purposes of eliminating it.
Right. But, I mean, in the face of a monopoly, have they ever granted forbearance?
I don't think it would be possible.
Exactly.
It would be absolutely counter to the basically you would then have to conclude that all of the FCC's regulations are unnecessary.
Exactly.
Larry, I want to interject too. When I use the term terminating monopoly, I'm accepting the argument of the FCC and others that is the case. As an economist, I don't really believe that the terminating monopoly argument is valid any longer in the broadband space. I think that terminating monopoly is a consequence of a particular set of regulations imposed on carriers in the past.
Right. The FCC, to be very clear, the FCC has described BSPs as terminating monopolists. We take the world as given. Agreed. Got it.
And I think we actually have, Tom Navin did talk about the one real world example that we kind of have of this, which I think, which is the competitive local exchange, terminating access problem, which, as he referenced, continues, pretty significantly. I think that was an example of an industry taking advantage of tariff rules to be able to kind of charge, pretty high rates for terminating service, but a lot of carriers also, the FCC's response on that was to regulate those rates and to prescribe them and to require that competitive local exchange carriers tariff their rate at the prevailing ILEC rate in the region. So the response to that was not de-tariffing. The response to that was to keep the tariffs in place, but to directly regulate the rates. And I think that is an instructive example that we have where I don't think the FCC would have been in a position to have forborne from tariffing requirements. And frankly, had they forborne from tariffing requirements for terminating access minutes, who knows what those rates might have ended up looking like? Because it's not entirely clear, what position the long distance company would be in when they're faced with the need to terminate a telephone call to a particular local telephone company. Right. So I think that it's not I think I'm kind of on the side that I think it would be extremely hard for the FCC to forbear from some kind of tariff rate notification, term and condition filing requirement under 203 in the face of what is, in the face of that terminating traffic issue that every edge provider and frankly every other broadband provider is going to face.
All right. Well, as we're hitting the sort of the end here, I do want to open up the discussion for some Q&A from the audience if that's available. So to the moderator, to our webinar moderator here, if you could ask if anybody has any questions, and we'd be happy to take them.
Okay, no problem. At this time, if you would like to ask a question, you can press the star and 1 on your touch-tone phone, and we'll go ahead and pause here to let questions queue up. Our first question comes from Lynn Stanton from Telecommunications and Reports.
Hi, Lynn.
Your mic is open.
Okay. I just have sort of a baseline question. I'm a little confused. George, you spoke both about it being solely this edge provider to ISP relationship that, as you phrased it, net neutrality is concerned about, and you made a point of saying that the data providers, by which I assume you mean the companies that provide transit, are not edge providers. But then you spoke about deep packet inspection, which I don't see why that would even be relevant if the traffic is coming directly from the edge provider, that the ISP doesn't need to use deep packet inspection to know which packets are coming from the edge provider. So I'm just kind of confused as to which relationship it is at the outset that you're trying to talk about.
Okay, I think in the picture we have arrows of relationships, not arrows of connections. I guess I think would answer your question. There's not necessarily a physical connection between there's not a physical connection between the edge provider and the BSP. There are physical connections between the consumers and the data carriers and the BSP. The edge provider lies inside the data carrier's trunks. So the deep packet inspection. I mean, this goes back to Jeff's point about the carrier-to-carrier relationship. I mean, if you think of what network neutrality is, I mean, we could take a simple case. Let's say we want to charge Netflix some kind of prioritization fee. Okay, Netflix may arrive over a circuit that includes the Phoenix Center's website. I mean, there are many, many edge providers being delivered by that particular carrier, one of which would be Netflix. And so the deep packet inspection issue is I'm going to go into that, within that connection, within that circuit, and find the traffic that I'm looking for and then treat it differently. And that's what the network neutrality argument is about, and that's why the deep packet inspection argument shows that it's about, is not a carrier relationship, but the broadband service provider going within a carrier's traffic and picking out particular types of traffic, and therefore making it about the traffic. Earlier this year has been about a direct physical relationship, if you will, between Netflix and Verizon, Netflix and Comcast, and when it was delivering its traffic itself and trying to have an arrangement. Right, and that is and that's not what you're talking about. That's an interesting and special case, and how that would play out, I don't know. Maybe Jeff may have more information on that. But what if some players, edge providers, become Title II carriers and choose to interconnect through that mechanism rather than through some other mechanism? But to do that, you have to. I mean, today you can do it without consequence because we don't regulate data interconnection. But if we relabel this a Title II service, then we're bringing it under that umbrella, and we have to start answering the questions about what is Netflix as a telecommunications carrier or not. That opens up a whole separate set of questions. But even then, I think that that could possibly provide even a cleaner opportunity. We don't have to buy the deep packet inspection equipment. We know who it is, and we can treat them separately based purely on that. And I'm sorry, it may seem like I'm kind of harping on this, but I'm generally just a little bit confused. So you're envisioning a situation in which, with the what you're calling a data provider in your chart, at level 3, let's say, that they are that the ISP would charge different rates to level 3 for traffic that was coming from Netflix than it would from traffic that was it was delivering for some small ISP that it had aggregated traffic from all of its small customers or whatever other kind of customer level 3 had that the traffic was originating from, as though an ILEC were charging a long-distance carrier different terminating rates depending on which of its subscribers the call was coming from? Those services are probably not, because those access charge tariffs are you're delivering the same service in all cases as a telephone call. I don't know exactly what the relationship would work out to be. It would depend. If it could be a situation where the BSP would charge the carrier for particular types of content. I suppose it would have to tell the carrier why. which content that is, so then that the carrier could pass that along to the subscriber. When I was in the CLEC business, you had either the option of paying your long distance carrier to pay the access charges for you wherever he delivered them, or you could separate that out and only buy the transit and pay the access charges yourself. So I suppose it might work out to be that way. It would depend on how the service, the specific details of how it got tariffed. But I suspect Jeff may be able to answer that question more clearly. He has more experience in that area.
We can try. I think the key point, Len, is that when you go to a Title II world as opposed to a world of contract law, the nature of the relationships between various parties changes, and it becomes one where what arrangements can be entered into are regulated and subject to the approval of a regulatory body, a state or federal commission in this case. And what's important,
I'm sorry, is it possible to do anything with your microphone, because you're just very fuzzy sounding?
So sorry about that.
Thank you.
And I think the key thing here is it's not just what the broadband service provider in a Title II world would want to charge or make available, but also what other people would be able to demand of it. It is important to note that special access is a great example. Actually, long distance carriers, local phone companies would like to very much not to have special access in the original days, because they could charge the same rate for everything, and what originally created special access was long distance companies that had large volumes wanted discounts. They wanted a different service. So, the notion of one size fits all, maybe in the case of Netflix, let's say, someone wants to compete with Netflix in a Title II world, they may want to say, look, I want to buy a superior service and I want to pay more money for it. And it's not clear whether the broadband service provider could do that or refuse to do that. And the whole thing would have to be put up into a legal and regulatory debate, and we would spend a lot of time trying to figure that out. The honest answer I think anybody has to have is we don't know how that would turn out.
Okay.
Any other questions?
I think Jeff right there brings up a very interesting point. This argument that we need network neutrality to protect entry is really kind of silly. An entrant may want to be differentially treated to have success. We certainly foreclose any innovation that would require a prioritized service. And we're also in a situation today where large companies like Netflix can afford to directly interconnect, and smaller companies might not be able to. So they can benefit from scale economies, whereas an entrant might not be able to. If the BSP could offer a priority service that mimicked direct interconnection, then that would facilitate rather than discourage entry. But that's another paper, I guess I should say.
Okay, we have time for one more question. Do we have one more question?
At this time, we have no further questions.
All right. Well, I appreciate everybody showing up for our webinar. The conversation was excellent. I know I really enjoyed myself. I hope everybody else did. I really appreciate it. If anybody has any questions about our paper or anything else, please do not hesitate to reach out to George and I. We'd love to talk with you. I'd like to thank my panelists again, Jeff Lanning, Koutsky, and Tom Navin, for an excellent discussion and for everybody turning up. And we look forward to seeing everybody at our next event, whenever that may be. Thank you very much, everybody.